and thank you for being part of today's webinar series. We're grateful to our speakers, Leonard Silk, Funke Adekoya, SAN, Mr. Shashore, SAN, and Roland Ziad from Linklaters. We thank you all for being part of this webinar, sparing time out of your extremely very busy schedule to share your wealth of knowledge with us today. Today we're looking at ICSID arbitration, and we have competent people who are going to be looking at this topic and share with us insights as well as proposed reforms. I'm just going to hand over to my colleague Adiola, who is going to continue from here while I stay to watch the webinar as well. Thank you. Adiola is our training manager.
Good afternoon, fellow senior advocates and Mr. Roland. You're welcome to the first launch hour series of the week. We're glad to have you here, especially because you have carved a niche in the area of arbitration, and you have been internationally recognized in this field. So we have no other person to lead this conversation today, and we're very, very delighted to have you here because we're rest assured that we'll pull from your wealth of experience and knowledge as we learn from you for the next 2 hours today. To lead this conversation, Mrs. Funke Adekoya, SAN, will commence. Mrs. Adekoya, over to you, ma'am.
Tosi, Ziad Roland is actually supposed to commence today's webinar.
Thank you very much. I was quite startled.
I think Roland is actually supposed to commence the webinar today.
Sure, happy to do so, no problem. I'm going to try to share my screen, if you don't mind 1 second. Up. So can you see my screen now? So good morning all, and good afternoon for those having lunch. So as discussed with the organizers, I propose to cover a number of topics. I will start with a short introduction on ICSID arbitration and arbitrating investment disputes. I will then tackle the constitution of the tribunal and some aspect of conducting an ICSID arbitration before concluding with the enforcement of ICSID awards. What I would say to start, and which will not be, I guess, a surprise to you, is that investment arbitration in general and ICSID arbitration in particular resembles commercial arbitration in many ways, but is very, very different in others. There are very specific issues to investment arbitration, both from a procedural and substantive standpoint, and the presence of a sovereign state in every such dispute can transform, in my experience, the tone and even more the nature of the dispute. Arbitral tribunals sometimes tend to be more attentive and engaged when a sovereign is involved, if only because of public policy and other considerations that often arises in investment disputes. ICSID and UNCITRAL, I have to say, arbitral rules govern the vast majority of investment cases. Out of approximately around 1,000 publicly known investment treaty cases, the clear majority of them were administered, in fact, by ICSID, and 1/3 approximately have been administered under the UNCITRAL rules. The ICC rules, just to mention them, are less frequently employed in investment disputes, strictly speaking, as a small fraction of BITs, bilateral investment treaties, and national foreign investment laws provide for an ICC dispute resolution option. To date, approximately 45 arbitration cases have been arbitrated under the ICC rules. I will focus, of course, on ICSID arbitration, which is at the heart of our webinar. What is ICSID and how does it work? ICSID was established by the 1965 Washington Convention as an arm of the World Bank, and it operates in accordance with that convention. Only investors from member states that can bring claim against other member states under the ICSID Convention. So ICSID operates within its own specialized framework, which distinguishes it from other arbitral institutions and systems of arbitration. In international commercial arbitration or in non-ICSID investment arbitrations, traditionally, the proceedings are governed by the arbitral rules selected by the parties, as well as the procedure rules of any applicable treaty, together, and this is very important, with the law of the legal place, the legal seat of the arbitration, known as the lex arbitri. By contrast, arbitration pursuant to the ICSID Convention takes place in a so-called self-contained procedural system, procedural regime, which is normally considered a-national, independent of any particular legal status, and governed by an international convention, the ICSID Convention itself, and the ICSID arbitration rules. This also means that the New York Convention on the Enforcement of Foreign Arbitral Awards and national arbitration statutes do not apply to ICSID arbitrations or ICSID awards. One very important point to bear in mind is that ICSID arbitration is designed specifically and exclusively for the resolution of disputes between states and foreign investors. To be able to avail itself of ICSID arbitration, investor must also demonstrate that the host state consented to resolve investment disputes under the ICSID Convention. As a result, access to ICSID jurisdiction is strictly limited by the ICSID Convention. In summary, I'll be very brief on that. A dispute must satisfy 4 conditions before it fails within ICSID jurisdiction. First, the dispute must be between an ICSID Convention member state or one of its agency or subdivision and a national from another member state. Secondly, the dispute must be a legal dispute, and to my knowledge, no party has successfully objected to jurisdiction on this ground. And thirdly, the dispute must arise directly out of an investment. The difficulty here is that the ICSID Convention does not define investment. This is in contrast with investment treaties, which typically do contain some form of detailed definition, as you may know. That said, certain common characteristics can be identified based on the so-called Salini test, which provides that an investment should be a contribution or commitment by the investor, of which performance is required for a certain duration, with the existence of a risk for the investor and a significant contribution to the economic development of the host states. ICSID tribunal, by and large, use the Salini test with adjustments sometimes, while taking into account the fact of their individual case. This condition of the disputes arising out of an investment has been the basis of frequent objection to jurisdiction and the focus of extensive debates. And fourthly, as I've already indicated, the parties must consent to submit the dispute to ICSID arbitration. This is a fundamental requirement of ICSID arbitration, and it is a formal requirement that the parties consent to ICSID arbitration be made in writing. This consent can obviously, and this is quite standard, be found in the contract itself, like in commercial arbitration. I'm referring to an ICSID arbitration clause included in investment contract. However, today, this consent usually consists of the acceptance by a party of a state offer of ICSID arbitration, which is found in a bilateral or multilateral investment treaties. And there are over, I would say, 2,800 at least bilateral investment treaty concluded and enforced. But such an offer can also be found in a host state's investment law. Therefore, and contrary to traditional contractual arbitration, investment arbitration is available to investor in the absence of a contractual agreement with the state. And this is very important. Because a protected investor may commence arbitration even if it has no prior contractual relationship with the host state, this type of arbitration is sometimes also called arbitration without privity. Among the important issues to consider before starting an investment arbitration, I would mention the exhaustion of local remedies as may be applicable, the cooling off period, and possible fork in the road clauses. You will see now on the screen summarized some of the most distinctive difference between ICSID and non-ICSID arbitration. I have already touched upon them and will not cover them again at this stage in the interest of time. To conclude on this introductory part, I would say that ultimately the choice among ICSID and other arbitration systems, to the extent that the applicable consent instrument offers such a choice, will depend on the specific characteristics of the particular dispute and on determining the most effective strategy to put forward in light of the overall circumstances. Often, but not always, parties opt for ICSID. I submit to you that this will have to be carefully assessed on a case-by-case basis. Let me turn now to the constitution of the tribunal. As you know, the appointment of arbitrators is probably the most important choice that the parties may make in an international arbitration. And I'm tempted to add, in particular, even more maybe in an investment arbitration. Basic qualification for arbitrators include a nationality here other than that of the disputing parties, which we don't have in a commercial arbitration. This was historically specific to ICSID, but has been extended to ICC investment arbitration. A command of the language of the dispute, technical and legal knowledge appropriate to the dispute, organizational skills, and of course, availability. Other less tangible attributes may be equally important in the selection of an arbitrator, making the appointment process, I submit, more of an art, in fact, than a science. Some of these characteristics include decisiveness, experience, sound judgment, and persuasiveness. To determine if an individual has the proper qualifications, counsel to the arbitrating party increasingly try to conduct an interview of arbitrator candidates. Immediately, let me say, it goes without saying that this conversation, if any, must be carefully limited to background, qualification, and absence of conflict of interest question to avoid tainting the candidate with a bias in any way. In practice, other considerations sometimes takes precedence in arbitrator selection. Counsel carefully score the candidate's published writings, arbitral awards, and dissenting opinion, and other professional activities seeking to ascertain whether the individual would be naturally disposed or at least not adverse to the appointing party's position. A claimant in investment arbitration, for example, may look for an arbitrator who has represented clients against government or state-owned enterprises in the past, or who has opined positively about expanded protection standard for investors. Of course, an established reputation within the industry in which the dispute arose, or with regard to the legal issues in dispute, is likely to better ensure the candidate's gravitas among his colleagues on the panel. It goes without saying that the participation of state parties has an important effect on the appointment of arbitrators in an ICSID arbitration. For instance, not sufficiently experienced arbitrators may be unacceptable to the claimant, since it is often perceived that only, rightly or wrongly, by the way, that only well-established adjudicators have the self-confidence or more the self-confidence to render large awards against states, which may have serious, of course, economic consequences for the country involved. From a respondent's perspective, it may be important to appoint an experienced arbitrator well-versed in international law, public international law, and familiar with the constraint of a state and the dynamics of serving as a member of an international tribunal. It is usually also a plus if the candidate happens to be familiar with the particular circumstances, environment of the respondent state. The availability of published ICSID awards often and the repetitive nature of certain number of issues that arise in investment arbitration and ICSID arbitration makes it all the more important for counsel to conduct a thorough due diligence. Let me now say a few words about the arbitrator selection procedure. Outside the ICSID system, the majority of international arbitration tribunals in disputes of significant size are, as you know, appointed in a rather similar way, broadly speaking. Each party names one arbitrator, and the two party-appointed arbitrator together, and often I would say in consultation with parties, agree on a third arbitrator who served as a tribunal chairperson or president. Under the ICSID rule and ICSID convention, the parties and not the party-appointed arbitrator act jointly, usually to select the chair of the tribunal. In order to do this, one party suggests two names to the other party as potential tribunal chair. The other party then either accepts one of the candidates or counters with a proposal of its own. If no agreement is reached within 90 days, then the request is made to the ICSID to appoint a chair. In practice, of course, as you can imagine, it is relatively rare for either of the parties to accept the chair nominated by the other side. And therefore, the ICSID Secretariat will often be left with the task of appointing the president of the tribunal. That said, the ICSID Secretariat has adopted a number of mechanisms to create a balanced and fair process to determine the president of the tribunal. When a party makes such a request in respect of the sole arbitrator or president, ICSID first conduct a ballot procedure, also often known as a list method. ICSID will provide the parties with a ballot form containing the names of several candidates who may or may not be member of ICSID panel of arbitrators. Each party will then give a short time limit to return its completed ballot form indicating the candidate it accepts and rejects. A party is not required to share its ballot with the other party, and if the party agree on a candidate on the ballot, then that person will be deemed to have been appointed by agreement of the parties. If the parties agree on more than one proposed candidate, ICSID select one of them and informs the parties of the selection. One final point worth noting on the appointment of arbitrators is that there is a growing body of guidelines and regulation governing the appointment of arbitrator in investment disputes, especially concerning disclosure and transparency, including a draft code of conduct of adjudicators in investment state dispute settlement prepared jointly by ICSID and UNCITRAL, and which third version was released a few months ago. For instance, it provides that adjudicators, defined quite broadly, should disclose all investor state cases in which they are or have been involved in the past 5 or 10 years. I'd say 5 or 10 years because currently in the draft there is 2 options and it's not yet settled whether they go for 5 or 10 years. It is worth noting that a few more recent BITs, such to take one example, the 2019 Dutch model BIT, have moved away from the traditional method of party appointment of arbitrators, opting instead for appointment by an appointing authority. This Dutch model BIT also precludes double hatting, i.e. acting generally both as counsel and arbitrator in investment disputes. Lastly, I have to mention that there is also a welcome push for greater diversity to achieve, a more balanced representation within the ICSID tribunal, among others between women and men, but not only. Still lots of work to be done, but an increasing push in this direction. I will now say a few words on certain interesting aspects of conducting ICSID arbitration and arbitrating against states in investment cases. I will be rather brief on this since time is running out, although we could spend, I have to say, a full session on this specific topic, and we may hear on that more from other speakers. When states and state entities are involved in arbitration, national interest and public policy arguments may play a role, and this may raise tricky questions of interplay between public international law and domestic law. The importance of public international law will, of course, vary depending on the facts of the individual case. When, for example, expropriation or expropriatory measures are the focus of a dispute, the rules and principles of international law relating to the protection of foreign investment will automatically play a central role. Likewise, in arbitration based on treaties, the rules and principles of international law relating to the interplay of treaties will often be decisive. In this context, the Vienna Convention on the Law of Treaties is of primary importance. Additionally, the law of state responsibility is in large part reflected in the work of the ILC, the International Law Commission of the UN, which is often referred to and relied upon in ICSID and investor-state disputes. Needless to say, it is essential that counsel and arbitrators be familiar with these areas of public international law. Of course, there is an increasing transparency in the field of investment arbitration in general, and ICSID arbitration in particular. And under the proposed new ICSID rules, there will be even greater transparency through increased publication of awards, decisions, and orders. For instance, a proposed new wording stipulates that absent a clear objection in 60 days, a party will be deemed to have consented to the publication of the award. And that's a trend that's followed the trend taken also by the ICC, even for commercial arbitration. Another important and novel aspect of the proposed amendment in terms of transparency is the adoption of rules mandating disclosure of third-party funding. I will not cover at this stage the sovereign immunity point mentioned on the screen, which we'll address briefly later with enforcement, and will just re-emphasize that objections to jurisdiction are very common in ICSID arbitration, often with bifurcation and sometimes even trifurcation of proceedings, which means that ICSID arbitration are often more protracted than other types of arbitration, and in particular, if you compare them to more traditional commercial arbitration. Host states have several lines of defense in ICSID arbitration. For example, under Article 41.5 of the ICSID arbitration rule and some modern investment treaties, state may move for early dismissal of a case on the ground that is clearly or manifestly without merit. Another line of defense, of course, consists, I've touched upon that, the jurisdictional objection previously discussed, which, if successful in a bifurcated cases, could lead to a relatively early termination of a case. States may argue that the claimant is not an investor or has not made an investment, or its investment doesn't qualify as a protected investment. State may also raise objection to jurisdiction or admissibility of claims, including on the grounds of bribery or other illegal conduct on the part of the investor at the time of acquisition or even sometime during the operation of an investment. At the merit phase, states may raise defenses and counter-argument to allegation of expropriation, breach of fair and equitable treatment, and other alleged treaty breaches. A common state defense in this context is relying on the state's police power to regulate or take measures in the public interest, even if those measures may cause harm to property right of foreign investors. In addition, investment treaties may provide for general exceptions or carve-outs, which may eliminate or narrow the scope of state responsibility for, let's say, taxation or measures involving the financial sector or national security, among others. These treaty provisions are broadly known as non-precluded measures or sometimes as safeguard. Another possible line, and the last one I've mentioned, consists of relying on circumstances precluding wrongfulness under customary international law. These circumstances include absence of consent, self-defense, countermeasures, force majeure, distress, and necessity. Among them, state of necessity has been used in a number of cases, including in the Argentine cases. Let me now conclude with enforcement. As you know, enforcement of an arbitration, an arbitral award, is a broad term that is often used to refer to any post-award attempt by the winning party to obtain the fruits of its victory. Enforcement can include confirmation or exequatur proceeding, or proceeding to execute an award by levying on the losing party's assets. The beneficiary of a non-ICSID award can rely usually on the New York Convention, as you know, while the beneficiary of an ICSID will take advantage of the ICSID Convention. In contrast to the New York Convention award, the ICSID Convention award should in principle be automatically enforced. In particular, Article 54 of the ICSID Convention, which you can see on the screen, provides, and I quote, "Each contracting party shall recognize and award rendered pursuant to this convention as binding and enforce the pecuniary obligation imposed by that award within its territories as if it were a final judgment of a court in that state, as if it was a final judgment of a court in that state." This is a very interesting and quite powerful wording. In some ways, ICSID award must be treated like a national court judgment, and a victorious claimant should be able to enforce the award directly in any state signatory to the ICSID Convention for any pecuniary obligation. Given the difference in treatment of monetary and non-monetary awards under the ICSID regime, claimant may be well advised to consider framing their demands as monetary claim, or at the very least, asking for alternative pecuniary form of relief if their primary claim for specific performance is not upheld. For example, an investor could seek specific performance of a state obligation to, let's say, reinstate a license, and also, as an alternative, liquidated damages for non-performance of that obligation under the governing law. This widespread usual compliance with ICSID arbitration award is due in large part to the effectiveness of the ICSID Convention enforcement provision, which ensures that in most circumstances, not all of them, but in most of them, a losing respondent will be unable to avoid enforcement actions in national courts. Finally, I would say that execution of investment arbitration award against asset of a state inevitably raise issue of sovereign immunity. As you know, national laws grant two types of immunities to sovereign: immunity from jurisdiction and immunity from execution. A state consent to submit to arbitration normally results in a waiver of immunity from jurisdiction. However, consent to arbitration does not automatically waive immunity from execution. And in most jurisdictions, a specific waiver is required to allow a sovereign asset to be subjected to attachment and execution proceedings. In that regard, since we're focusing on ICSID, Article 55 of the ICSID Convention specifically provides, and I quote, nothing shall be construed as derogating from the law enforced in any contracting state relating to immunity of that state or any foreign state from execution." This article clarifies that by submitting to ICSID arbitration, states do not waive their immunity from execution in national court of ICSID member states. While in many jurisdictions, sovereign immunity has weakened in recent decades, the issue remains central to any execution attempts against a state and raises a range of complex legal questions that are frequently, of course, litigated. Naturally, the local requirement for enforcement against sovereign asset must be observed and ascertained on a case-by-case basis. It is therefore important, I submit, to retain the assistance of experienced local counsel to assist in this process, particularly in complex multi-jurisdiction attempt to collect arbitral awards. I also think it is advisable, not to say critical, to start considering these issues of immunity at an early stage, i.e. before obtaining a final award, and in fact, even when entering into an agreement. This can be done by securing, to the extent possible, a waiver of immunity if you are representing the investor, or by making sure that the immunity is preserved if you are representing the state. In light of the time, I'll stop here. Thank you. I'll hand over the floor.
Thank you so much, Mr. Zeid. That was a very lucid exposition on the introductory part of this conversation. And I'm wondering if anybody has a question to ask rather. Okay, I think I have a question while we wait for our audience. And I want to ask, what's the difference between ICSID and uncitral model? The uncitral model.
Yeah, the difference probably between ICSID and the, you may be referring to the uncitral arbitration rule. The uncitral rules are rules that have been edicted under the imprimatur of the UN nation. They're ad hoc arbitration, so it's an ad hoc, they're used when you don't have an institution that is governing an arbitration. They're very well spread. They're often appreciated by states. Because there is this UN imprimatur. They've been used extensively historically for the US-Iran tribunals. So there is a body of rule that is available. Now, even if you have, I would say, an ad hoc arbitration governed by uncitral rule, you can nonetheless have also an appointing authority, which can be, let's say, the PCA or even the ICC, which would play a role in the nomination of tribunal in challenges. So it's the uncitral rule is probably the most used rule in investment arbitration today after ICSID. I had mentioned probably 1/3 of investment arbitration rules are governed by the uncitral rules. Now, you touch upon also the model law. The model law is more in relation to the statute, national legislation in certain states, so it probably has less relevance with respect to investment arbitration. I hope I've answered your question.
Yes, you have. I have one more question, and I'm wondering how effective ICSID arbitration has been so far, considering the World Trade regime. Have parties been resorting to submitting the investment dispute to ICSID in recent times?
Yes, and even I was checking the latest statistics. There is an increase of a number of cases submitted to ICSID over the last few years. Again, mostly based, I would say, on bilateral and multilateral investment treaties. It's more rare or less common, I would say, that party agree contractually. There are a number of ICSID cases that arises from contractual relationship, but most of the ICSID arbitration arise, I would say, from investment treaties, either multilateral treaties like the ECT or more often, I would say, bilateral treaties.
All right, great. Thank you so much. And Mrs. Adekoya, the spotlight is on you right now. Thank you, Mr. Zeid.
Thank you, Roland. If you stop sharing your screen.
Yeah, I'm going to try to do. I'm trying to do that.
And whilst Roland is taking down his screen, I will say good afternoon to everyone. It is a lunchtime webinar, so irrespective of where you are, it is afternoon here. So good afternoon. One caveat, which is that Roland has touched upon some of the things that I was asked to look at. I will, however, try and repeat a few of the things that he has already mentioned. I was supposed to speak on the structure and jurisdiction of an ICSID, and now I can't seem to find my PowerPoint. Okay, found it. Okay, can you see my screen? I was supposed to speak on from the perspective of the structure of a typical arbitration proceedings under ICSID and focus on jurisdiction and annulment. And Roland has spoken on some aspects of that, so please, I apologize if I will be repeating him in some aspects. The first thing is, as Roland laid the background, the basis for ICSID jurisdiction is Article 25 of the ICSID Convention. The wording of that Article 25 is on the screen, and I will take a moment to allow everyone to read the wording. It refers to a legal dispute. The legal dispute must arise directly out of an investment. The dispute must be between a contracting state and the national of another contracting state, or the national of a contracting state and a subnational entity of another contracting state. The parties must have agreed in writing to submit their dispute. So where does that take us? In terms of jurisdiction, there are three aspects that one looks at in terms of ICSID jurisdiction, and they're called ratio materiae, ratio personae, and ratio temporis. And anyone who's interested in investment arbitration or investment treaty arbitration, because they're not necessarily the same thing, I would advise should firstly have some opportunity to read cases. There are a lot of awards online that you can just download and read. And if you read those awards, you will come across these words. And so it becomes important to understand what exactly is ratio materiae, ratio personae, and ratio temporis within the context of jurisdiction to hear a dispute. Ratio materiae refers to the legal dispute arising directly out of an investment. So obviously, the first thing is there must be a dispute. It must have arisen from or be connected with an investment. As Roland had mentioned, investment is itself not defined in the ICSID Convention. It may be defined in a BIT, it may be defined in a commercial agreement, or it may depend on a factual situation. Where investment is defined in a BIT, the wordings of the BIT become very important because different bilateral investment treaties or multilateral investment treaties may have different definitions of what constitutes an investment. Obviously, if it's a commercial agreement, then the wording of the project, or perhaps even the wording of investment itself, may be found in that document. But in a situation where there is no such place to go back and look at as to, is this an investment or not? Then what does one do? And in those circumstances, as has been stated, again, repeating Roland, there's what's called the Salini test. And he's already mentioned the highlights, and I will just, it bears some level of repetition, and so I will repeat. Salini test, 4 criteria. There must be a contribution. So the investor must have brought something to the table, and usually it's money. Sometimes it may not be money, it may be project management, as in putting a project together. The investment must be a certain duration. There must be an element of risk, and there must be a contribution to the economic development of a host state. And the case that Roland has mentioned is the case that I have just referred to. It's Salini and Easter's trade against the Kingdom of Morocco. And those are the details. So you can, after this webinar, go online and look for the case and actually read it and understand how the tribunal came to what is now popularly known as the Salini test, which many tribunals look at in trying to determine whether there has been an investment. And I say this because in one of the matters in which I am involved, one of the arguments of the state party was that there was no contribution. The investor didn't put down a brass farthing. And therefore, even if there was a project, there was no financial investment involved in it. And therefore, the Salini test will then give you an idea in other cases as to what a contribution means, whether it's a financial contribution or it's sweat equity or something else. So we then go on to jurisdiction rationale personae, a contracting state. That seems to be clear. The state must have ratified the ICSID convention, or a subdivision or an agency of the state has been designated by that contracting state to ICSID as being capable of being a party to an ICSID arbitration. And there are hardly any issues that come up in respect of ratione personae when you are in the context of a contracting state. One, because in many cases, the dispute has come under the auspices of a bilateral investment treaty, and the state is a signatory to the treaty, and is possibly already a signatory to the convention as well. So that's sorted. Now, the issue is where it is a national of another contracting state. The investor will benefit if he's entitled to benefit from protection guaranteed by the underlying BIT. The national could be a human, a natural person. We have many cases in which individuals have brought claims against states. Some of the expropriation cases that came out of Zimbabwe, the land equalization of land policy of the state of Zimbabwe resulted in individuals bringing ICSID claims. In addition, national is also defined as a juridical person, so a legal personality. That legal personality must have the nationality of a contracting state other than the state party. In many countries, especially in many countries in Africa, where local incorporation is required to enable a foreign entity do business within jurisdiction, does that then mean that there's no availability to the owner of the locally incorporated business to bring an investment treaty arbitration or an ICSID arbitration? And the answer is no. Because where the country requires local incorporation as the business, as the basis, then it is still classified as a foreign investor, depending on its shareholding structure. If you're 100%, if the local entity is 100% owned by a foreign entity, then there isn't an issue. It is where the foreign entity is maybe owns only 60% or 70% of the juridical person that is the claimant in the investment treaty arbitration, that issues may arise. And then the claimant will have to prove not only that it is a locally incorporated entity, but that it is under the control of this foreign entity. And this foreign entity exercises sufficient control over it, either through shareholder agreements, positions on the board, or other structures. And it is also in these situations have the opportunity to access a BIT, depending on the ownership of the foreign entity. So that's where ratione personae becomes important in terms of ICSID jurisdiction. Consent in writing, it's clear. Once the host state has either incorporated an ICSID arbitration clause into contractual agreements or as I believe Shukwa will tell you when he speaks through his own personal involvement in ICSID arbitration, where a host state through its national investment laws has consented to ICSID arbitration, or there's a BIT, bilateral investment treaty, or a multilateral investment treaty to which the state is a party. The state has consented in writing. The investor consents in writing by filing the request for arbitration. And so the third aspect of jurisdiction is called ratione temporis. And that refers to the effect of time on the tribunal's powers where it's brought pursuant to a treaty. Roland had mentioned a cooling off period, for instance. Have you filed your claim before the cooling off period has elapsed? At what time did the dispute arise? And at what time did the investment arise? And these are things that the tribunal takes into consideration in determining whether these three aspects of jurisdiction, personae, materiae, and temporis, are available. For instance, the tribunal's jurisdiction does not extend ratione temporis to breaches that took place prior to the making of an investment. So the timing of the investment is important. Obviously, supposing at the time you had made your investment, there was no BIT. Would you then be able to take protection under the BIT when it comes into place? And these are the things that ratione temporis deal with. Jurisdictional challenges. A jurisdictional challenge can arise if there's lack of consent, if the timing of the dispute is, if the time the dispute was submitted is in contention, the nature of the dispute, or the fact that parties are not parties to the dispute as prescribed by Article 25. Now I'll go and do a quick flow chart of the conduct of an ICSID arbitration and basically run through. And on the screen, I have put the credit to where you can actually find this flow chart. And this is basically how an arbitration proceedings runs. The requesting party files the request. It's filed at the ICSID Secretariat. I think the fees at the moment are $25,000 or so. The request is screened and registered. And there's a possibility for the ICSID to refuse registration if it is so blatantly clear that there is no ICSID jurisdiction. For instance, if the party against whom the state party is not a contracting party under ICSID, hasn't signed the convention, then there would be no jurisdiction. In cases where the Secretariat may be unclear as to whether or not there is jurisdiction, the dispute is registered and the tribunal has the power to look into its own jurisdiction. So you bring up your jurisdictional claims there. Then the number of arbitrators and the method of the appointments are established. And Roland has spoken about that, and I will not go into any further details on that. So once the tribunal members are appointed, then the parties are told that the tribunal is constituted and the proceedings begin. The tribunal holds a first session with the parties, and there's a time frame within which that first session ought to be held. And the first session is what in domestic arbitration we call a preliminary meeting. In ICSID arbitration, it's usually called either a case management meeting or a first procedural meeting. And that lays out the framework for how the disputes will be determined and the proceedings of the arbitration. And there would be a procedural order which would be quite lengthy and would serve as a guidance to the parties at every stage of the game. After or as a result of that case management or the first procedural hearing or first procedural meeting, the parties will determine what the written procedure is going to be. Issues as to jurisdiction, merits, damages, they may be addressed separately or jointly. If they're addressed separately, then there may be an interim decision on jurisdiction. If the stages are broken down into jurisdiction, liability, and then merits, you may find out that there may be an interim decision on jurisdiction and an interim decision on liability. And then you go into a damages hearing. Then parties would also agree on what's the oral procedure. Same thing, jurisdiction, merits, will they be addressed separately or jointly? And then the next thing is you have deliberations. The usual procedure would be that in ICSID proceedings, most things are written. So you'd file memorials, the parties would determine, usually it's 2 rounds of memorials, both sides would file the memorial, then a counter memorial, then a response to the counter memorial, then a rejoinder to the counter memorial. You would file it together with written evidence, and you'd file it together with a list of your legal authorities to support the positions that you have taken. Then you have the hearing, deliberations. The parties appear before the arbitral tribunal. Now everything is done online. I was in a position moaning last week, or well, I was being moaned at because my co-arbitrators were sitting in countries where it was snowing, and I was enjoying the heat of Lagos. So now tribunals tend to sit online, but in the past you traveled and the parties met and the tribunal met, and it could be 4 days, it could be a week. And then at the end of that, the award is given and that disposes of the case. Now, after the deliberations, after the hearing, the usual procedure is that the arbitrators will stay on for a day or maybe 2 days and deliberate among themselves, tribunal deliberations. And if parties have agreed on post-hearing submissions, which is usually the case, then after post-hearing submissions are in, then the tribunal may have a further set of deliberations. So you may find out that where jurisdiction, as in one of the matters that I'm involved in, where there's been an argument as to jurisdiction, at the end of the hearing, the tribunal first of all met and we discussed jurisdiction, whether we had or we didn't have. And then when that was determined, we then had another down the line discussion on merits. And when there was an agreement as to merits, we then said, okay, now we need to have another discussion as to damages. So you find out that the deliberation stage, which goes on behind the scenes, is much longer or as long as the hearing stage, which means from filing of your processes to actually appearing before the tribunal. In the corner of the slide, I have mentioned other procedures that could come up. I will not touch on them in any great detail because I am very aware that I also have a time constraint and I still have one more issue to discuss, and that's annulment. But once you finish your deliberations, you write your award and that award disposes of the case. However, unlike court litigation, ICSID provides for something that is very different, which is an annulment procedure. The annulment procedure is governed by Article 52 of the Convention. Either party may request annulment of the award. The important thing that one needs to note is that annulment is not an appeal process. So it is not an opportunity for parties to re-argue issues that have been ventilated before the tribunal. The annulment committee is established by ICSID. The parties to the original proceedings are not involved in determining who the annulment committee is. The annulment committee is totally separate and independent. I'm privileged to have sat on 2 annulment committees. And because it is an annulment committee, what you are looking at is the award against the backdrop of the grounds for annulment. And these are the grounds for annulment. The the tribunal was not properly constituted. The tribunal has manifestly exceeded its powers, which is something that most parties seeking annulment tend to rely upon. And manifest excess of powers is either the tribunal exceeded the powers or did not utilize the powers it was given, or utilize the powers in a wrong fashion. Corruption on the part of a member of the tribunal, serious departure from a fundamental rule of procedure, or the award has failed to state the reasons on which it is based. Most annulment cases come under manifest excess of powers, serious departure from a fundamental rule of procedure, or failure to state reasons. And there's a lot of case law noting that ICSID decisions are not precedents, but do provide guidance as to the various circumstances where failure to state reasons rises to a point where it then becomes a ground for annulment. The essence really is that once you're able to understand how the tribunal reached its decision, you cannot really say it has failed to state the reasons. It may not have stated it clearly, it may not have stated it intelligently, but it has stated reasons. The reasons are stated there. The annulment procedure also is lengthy. It tends to take anywhere from a year to 2 years to conclude. But having said that, the statistics do tend to show that in most instances, or let me say in many instances, I think about 70% of awards, the annulment procedure fails. However, there have been issues where annulments have succeeded. So I've told you the time frame. The annulment must be made, the application must be made within 120 days from the date of the award. If there's corruption, if it's an allegation, then it must be made within 120 days after the discovery of the corruption, but within a time frame of 3 years anyway. So the annulment procedure is also restricted in terms of time, and that is to ensure certainty of some form in the dispute resolution process under ICSID. Thank you very much. I think I have just breasted the tape.
Yes, we had another insightful moment. And we have 2 questions from the audience. The first is from Adetola actually both are from Adetola Adebenson, and she's asking, or he's asking, in world duty free, the ICSID tribunal found that an investment tainted by corruption was not a protected investment under the relevant BIT. What is your view on whether this should be treated as a threshold issue of jurisdiction stroke admissibility barring the claim, or whether the host state in pari delicto, the fact of the corruption, should be taken into account for the purpose of the compensation in the final award?
That's a very interesting question. The first issue is corruption as a jurisdictional bar. And that seems to be the position that World Duty Free and Egypt took, that you cannot access the investor settlement dispute system on the basis of a corrupt investment. If you read World Duty Free, the elements of corruption were extremely clear on the face of the record. And so it was very easy for the tribunal to dispose of the case on a jurisdictional level. The second part of the question is as to whether the state can or should be allowed to use the corruption of its own officials as a shield in resisting an investor dispute. In circumstances where its own officials have benefited from the investors' generosity, for want of another word, and in circumstances where the state has also benefited from the investment. And as a result of the dispute, the state then says, I'm going back to my books, I'm having a look. Actually, there was corruption, either in the mode in which this investment was procured or the mode in which licenses were obtained, and therefore I should not be liable. And there are two trends of thought. There is one trend that says at that point, it is not a jurisdictional issue because the dispute is already before the tribunal. It's being raised as a defense. And therefore, there should be different circumstances and different principles which should apply. And I think the main principle that tribunals struggle with, and I am not going to give a view, is whether a state that has benefited from an investment should then be allowed to say, well, I'm sorry, you corrupted me and got my license because my staff or government as government was corrupted. And now that the relationship is not as it used to be, I'm sorry, I am disowning that investment, especially in circumstances where the investor cannot take away the investment. So I will leave it there. I won't take a view on either side. I can understand the problems that a tribunal would have in trying to say whether a corruption should be allowed as a defense and what happens thereafter.
Thank you very much, Mark, for that response.
I'm sure Mr. Shashare has views.
I'll keep my gunpowder dry. I think it's I totally agree with you. I think it can be used as a threshold point, and I really do not see how any tribunal applying the normal known concepts of justice should let a state party take benefit from a corrupt act in order to protect itself from an enforcement. It's, I mean, the dictates of normal justice would demand that. But, and it's a growing problem. It's a growing problem.
No, I fully concur and would highlight that applies obviously for investment arbitration. Commercial arbitration, the approach would be different, and the tribunal will retain jurisdiction. There is no longer any issue of arbitrability as it was maybe 25 years ago, but then the tribunal will have to uphold public policy by, let's say, annulling the contract and taking all the resolution that is required under the circumstances.
Thank you to the entire tribunal. It felt like another ICSID tribunal, mini mock tribunal. Thank you so much for your contribution, Mr. Shashore and Mr. Zeid. You have two more questions, Mrs. Adekoya. And Raymond is asking, he says, are annulment proceedings always at the instance of the unsuccessful party at the arbitration? And what is the fate of the awards made during the course of annulment proceedings, particularly where the annulment proceeding is at the instance of the unsuccessful party at the arbitration?
Well, the first thing is that annulment proceedings are always at the instance of the unsuccessful party. The unsuccessful party may be the state, where an award has been made against it. The unsuccessful party may also be the investor, where its dispute, where its claim has been rejected. So either party, either a state or the investor may be an unsuccessful party, but it's always the unsuccessful party who brings the annulment proceedings. What is the fate of awards made during the course of annulment proceedings? They are in force, and invariably, what happens is that whilst the annulment proceedings are ongoing, the successful party is doing everything possible to ensure that it obtains the rewards of a successful award in other countries. The annulment procedure also allows ICSID to grant a stay of enforcement within the ICSID setup. Where that happens, then the parties would be stopped from bringing fresh enforcement applications. But where enforcement applications have gone on already, then it is left to the countries to decide whether or not the fact that there's an annulment proceeding ongoing will stop them from enforcing that award. Having said that, especially I use Spain as a recent example, because there've been a lot of annulment, there've been a lot of awards in recent years against Spain as a result of the Energy Charter Treaty and the issues with EU law. And it seems as if so far Spain has managed to successfully resist having those awards enforced in various jurisdictions, Australia, the US. So some tribunals, some courts will take into consideration the fact that annulment proceedings are ongoing.
Thank you, Ma'am. Although Matt is asking similar questions, I don't know if I should repeat the second aspect of his question. He's asking, can a party who has unsuccessfully resisted enforcement of an ICSID award fall back on the annulment proceedings using the same ground, assuming it is within time?
Well, firstly, the grounds are not the same. The grounds for resisting enforcement are extremely limited. The reason being that once you have an ICSID award, it is equivalent to the award of the highest decision of the court in the enforcing stage. So the proceedings, the attempts to resist enforcement would probably be if you brought if the enforcement has been brought under the New York Convention, then you can bring up issues of public policy and things like that. But if you have not, your award is going to be enforced. And you cannot fall back on annulment proceedings because the grounds for annulment are totally different. It's not an appeal. It is extremely restricted. Failure to state reasons, manifest excess of powers, breach of a fundamental rule of procedure. It's quite, the bar is quite high. So it's totally different from commercial arbitration.
Thank you so much, ma'am. So we're moving on to the final speaker, who will be taking us towards the ending of this conversation. And we're very, very sure that we're going to have, a balanced diet on this ICSID conversation. Mr. Shuko-Shashere, over to you. You have 20 minutes and then 10 minutes for questions. Thank you, sir.
Well, thank you very much. Well, it's always good to be the last speaker because you're very sure that the previous speakers would have covered most of the areas that you would otherwise have loved to talk about. So it leaves me with only 3 topics that I'll cover. The history of ICSID and Africa, the certain delicate reforms that I think the convention system requires, and then the interesting matter of the ACMEA case, the European case, in the context of the future coming AFCFTA treaty agreement across Africa. I'm mindful of the fact that much of the audience will be either Nigerian, African, or people who have interest in such matters. So I will dwell a bit on Nigeria and Africa. But my next caveat is, first of all, I don't have slides. I think I was misled by the lunch hourness of the arrangement, thinking that it was much less formal discussion. And my next warning is that if you if I come across as being overly critical of the ICSID system, please don't use it as an excuse not to brief me if you ever have an ICSID. I love ICSID. I love the system. I just think that there are several things that we can do better, and we should look to change. So that's all my housekeeping in a box there. So a little bit of, and anybody who knows me anyway will know that there's no way I wasn't going to talk from a historical point of view as well. So there you go. I'm going to do a bit of history at the beginning. Yeah, we know, created in the 60s, created in 1966. It's a world leader, by far, clearly the world leader in international investment dispute settlement systems. I think as at the 31st of December last year, ICSID had registered 869 cases under the convention and an additional facility rules. It doesn't take a genius to guess that a good overwhelming majority of those cases involved African states as respondents. ICSID has administered over 70% of all investor state disputes. And clearly it is the only institution designed by states for investment settlement disputes. And it's the only institution that can administer the convention. But as to Africa and a bit of history, I did mention that in 1966, the convention came into force. The first signatory to the convention was an African state, Tunisia. And the first party to ratify the convention was an African state, Nigeria. And so you could see that Africans have long had a strong relationship with the ICSID system. Whether they've had a fair shake is up for debate. There is a general thinking that African parties have not been as successful as one would ordinarily imagine, given the overwhelming majority of their involvement in disputes before ICSID tribunals. Now, the first counter you give me is that, well, if they're at fault and their cases are bad, then they lose. But perceptions are very important, and many African states are taking a very skeptical look at the ICSID system. Not that it is justified, but I just said to put that on the table, that it is getting a bit of criticism from African parties. Now, what was why were African states so involved in its creation, and why were they the early? In fact, I think out of the first 20 parties to be a part of the convention, the first 15 were from Africa. So there was a huge rush to get involved. And I think it came from the general thinking in the 60s. And if you think about the case of Nigeria, we ratified the convention in August of 1966. And if you know anything about the history of Nigeria, we still had the wherewithal to ratify an international convention on trade, on investment in those very already tumultuous and difficult times. But the compelling reason was essentially the general thinking that had come from the World Bank and the World Bank system, which ICSID is part of. I'm going to read from a small part of the report of the executive directors of the World Bank on the convention in the 60s, to give you an idea of the rationale behind how African countries were driven to participate in this system. In their efforts to attract foreign investment that may be needed more now than hitherto, meaning that now that the African states in the 60s had gotten their independence, majority of the African states were getting independence. And so they said the thinking was that foreign investment was needed more now than hitherto. I can't follow that reasoning. Contracting states in Africa, and indeed in other regions also, should find the ICSID mechanism and their membership in the center to to be of continuing great relevance and value. By the same token, it may be hoped that the few countries in Africa that are not yet ICSID members, such as Ethiopia and Zimbabwe, may soon add joining ICSID to their other efforts to attract foreign investment. So it was being sold as a great tool of foreign investment. Indeed, many African states, even after becoming part of the ICSID system, went on to pass investment promotion laws that did away with the need for consent by literally giving a unilateral consent to arbitration under ICSID in a statute of its own National Assembly or Parliament, and therefore making it even easier to get themselves dragged before ICSID by a foreign investor. Now, this is not to say that the standards of treatment of investors has always been the best, but the thinking was that the World Bank system was choosing to protect the inevitable and in the beginning stages, European investor from the possible machinations of rather less than competent African state, so to speak, with my tongue in cheek, obviously. So there you had it, starting off on a very uneven balance. The system came into fruition. And you'll see it in some of my commentary that it has had there's much more to be desired. In fact, African states having decided to join the convention, there was supposed to be a lot of mutuality, reciprocity of both benefits and obligations. But in the case of Africa, it was put forward as a developmental necessity that the ICSID world would stimulate in investment. Now, given today's present day realities and the growth of China investment in much of Africa, it can be assumed with a lot of respect that the convention hasn't succeeded in that regard, because the incursion of China, who is not one of the European countries who at the time were insisting that this was a sine qua non to foreign investment, still invests heartily in Africa outside of the hope of using ICSID as a settlement disputes, investment dispute mechanism. So, in fact, I want to commend the views of W.E. Albrecht in his St. Louis University Journal article, where he raises some questions concerning ICSID. By maintaining a careful balance between the interests of investors and those of host states, the convention attempts to provide an impartial forum to resolve investment disputes. But it must always be remembered that the convention is merely one means to an elusive end. There is no substitute for stable, cooperative atmosphere in the host state. Its policies and political climate are the most basic considerations to an investor. Nothing could take the place of confidence. This is the decisive factor in foreign private investment. So any one of you out there that is in an investment promotion agency should try and head off the hope of a dispute by ensuring that foreign investors are fairly and equitably treated. Now, just to talk about Nigeria's ICSID experience briefly. Before 2020, there had been only 3 known investment settlement dispute cases against Nigeria. There you go again. Nigeria was a respondent, not the claiming party. The first 2 of these cases, the Guadalupe gas products case, you can find the citation online, and the Shell Nigeria Ultra Deep Limited case against Nigeria. Both were ultimately settled, and the terms were not made public. But the third case, Inter-Ocean Oil Development Company, the Inter-Ocean Companies versus Nigeria, The award was delivered on the 6th of October 2020, which I was personally involved in. It was heard on the merits. It was the first to be heard on the merits over the period of 3 years, and subsequently decided in Nigeria's favor. There are now, I think, 2 new cases, ICSID claims against Nigeria, again, against Nigeria, ENI International, BV, and Nigerian, and then the Nigerian AGIP exploration case. Yeah, it's the same case, ENI and Nigerian AGIP against Nigeria, and Shell Petroleum and Shell Petroleum Development Company versus Nigeria. And they were both registered in 2020 and 2021, respectively. So you see, Nigeria has been busy in a very challenging atmosphere and rules of compliance procedure that ICSID can tend to be. I will move on to, having set the stage with Nigeria, I said I'll look at some mild criticisms, and then we'll talk about the ACME FCFTA. Yeah, there have been widespread concerns regarding ICSID decisions, and I'm sure both Roland and Funke will agree with me. I think one of them, I think Funke alluded to that. There have been these concerns around consistency in decision making, because decisions are not binding, coherence, predictability, and all aspects of the same thing. And then generally the sense of correctness that tribunals sometimes instill in parties. Inconsistent findings have manifested themselves in 3 broad scenarios. Tribunals have reached different conclusions about the same standard in the same investment treaty, or about the same procedural rules, including where the facts are similar, or where such differences are not sufficient to justify a different outcome. Tribunals under different investment treaties have reached different conclusions about disputes involving the same measure, related parties, and similar treaty standards or applicable rules. And finally, tribunals organized under the same or different investment treaties have dealt with disputes involving unrelated parties, but similar facts, and have reached opposite interpretations over the applicable legal rules. One of the, my guess is probably the best example of this inconsistency is the Czech Republic, the CME and Czech Republic decision, where an American entrepreneur brought a claim under the US-Czech BIT in the 90s against the Czech Republic, alleging that his investment had been expropriated. The investment was through a Dutch company over which he had no control. The expropriation was done through a Dutch company over which he had no control. CME brought its own claim under the Dutch-Czech Republic BIT. Tribunal was comprised of different arbitrators in each case. However, since the allegations against the Czech Republic were substantially the same, the evidence presented to the 2 tribunals was more or less the same. In the end, the 2 tribunals delivered their awards within a week, 10 days of each other, but arrived at completely opposite outcomes. Dismissal of the claims in one case and an award of damages in the other. And there's similar examples that those of you who are frequent prowlers of ICSID cases will be aware of. And now, these areas of inconsistencies include questions of such as jurisdiction and the admissibility of the claims, whether they will be admitted, and the broad interpretation of Article 25, which has been alluded to by both previous speakers. whether the contribution to the host state's economic development is part of the criteria to be considered in the definition of an investment. I think I talked about that. Whether portfolio investments are protected, where there is an appearance of no actual boots on the ground, and whether the effective control of a claimant over the relevant entity must be merely legal or also factual for the purposes of determining a claimant's right to bring an investment claim. Now, this occurred in the case that I spoke about, the inter-ocean cases, where the Nigerian investment promotion legislation had said it would protect enterprises who have made investments. And the difficulty was that the definition of enterprise was unclear, and the definition of investment was even unclearer. And we spent a good deal of time trying to cross the bridge in jurisdiction. We crossed the bridge eventually and went into the merits. Other major areas of divergence in decisions are in respect of the interpretation of the cooling off period for the whole concept of exhaustion of local remedies, and generally how to interpret the fair and equitable treatment standards. Again, to refer to the inter-ocean case, we accessed the court's jurisdiction through the legislation and the unilateral consent of Nigeria to submit to ICSID arbitration. But we also felt minded that the court had jurisdiction to apply international investment law as a matter of international law, public international law, which created much heated debate, which we won on the preliminary grounds, but when it came to the final decision, it became the undoing of the case itself. So, the other issues of customary international law, the doctrine of necessity, treaty-based defense, these are all areas where the tribunals have come out with conflicting and sometimes inconsistent decisions. You'd ask yourself what to do about this. I can't just complain without proposing some reforms. So thankfully, UNCITRAL came to the rescue. Since 2017, there have been multilateral efforts to reform the system in order to promote a fair and inclusive system to resolve investment-related disputes. UNCITRAL in 2017 issued a mandate to a working group with clear terms of reference to identify and consider concerns regarding the system, to consider whether reform is therefore desirable, and if so, to develop, and I think we all know the answer to that, and if so, to develop any relevant solutions to be recommended to the Commission. And the reform discussions were divided into 3 phases. During the first phase of the reforms, countries built consensus on the need for reform, identified reform areas and approaches, and reviewed their international investment networks, agreement networks, developed new model treaties, and started to negotiate new and more modern treaty systems. Therefore, UNCTAD proposed 10 policy options. In total, kind of conclude. 10 policy options, and they're all out there. If you want, you can visit www.investmentpolicy.unctad.org. Now, I want to talk, I must get squeezed in, whether they want me to round up or not, I must talk about the ACMEA case. Now, the ACMEA case, for those of you who've come across it, was a Dutch investment in Slovakia. The dispute arose and it was brought before a German court under the Dutch-Slovakian BIT. Essentially, by cutting to the chase, and I'm not a European law expert, but certain astonishing things were revealed to non-European law practitioners. And that's the insistence and the jealous protection of the ECJ, the European Court of Justice, and the European domestic courts. And the court came to two things that it noted immediately: that the freedom of investment, the freedom of the investment tribunal to choose its seat, and consequently to the law applicable, was of great concern to the court. And secondly, it also noted that judicial review of its awards by these tribunals, these alien tribunals, was very limited under many of the laws of Europe. And it said that its reason for its decision was essentially the fact of these three key features: that it was possible for tribunals to interpret EU law, and that these tribunals were essentially not part of the EU judicial system. And therefore, ECJ had very limited means of reviewing the awards, and therefore rejected the claim that the preliminary point that was brought before them, and declared essentially that it was inconsistent with EU law, broadly speaking, and that essentially brought about an end to the possibility of either enforcing ICSID awards in Europe or applying ICSID treaty convention disputes in the EU, between EU parties. Now, it's a head scratcher for most of us who are non-European lawyers, because it then means that, hang on, Europe has rejected the ICSID system and essentially said that you can't even come and enforce. So imagine in a BIT, an investment dispute outside of Europe, and I find the assets of my, I'm the award creditor, and I find the assets within a European, I may even have problems bringing such an ICSID award to enforcement before a European court, before a European court. It's alarming to those of us who are outside Europe, and it's alarming because in a place like Nigeria, where the general footprint of defaulting award debtors is likely to be in a European city or a European state, it leaves you with a lot of empty choices. Now, given the emergence of the AFCFTA, the largest free trade agreement in the world now, and the proposed dispute mechanism that is being proposed, even though right now it's limited to state, I have it on good authority that it will be expanded to involve investor companies and investors. What would be the attitude of Africa towards that sort of jurisprudence coming out of Europe? Would Africa emulate that and say that if you had an award from a non-African party, a party that was not party to the AFCFTA, you could not bring it before African courts? I doubt it, but this is kind of tit-for-tat jurisprudence that we could get into, and it could cause a big breakdown in what has till today been a harmonious system in instilling confidence between investor and state in the hope of resolving disputes under a predictable, well, relatively predictable atmosphere. I saw the message to me to jump off, but essentially that's my presentation. I hope I wasn't too harsh. The result of ICSID and its current constitution means that very few African countries are seats. All right, very few, not so many African parties are made. Personnel are made ICSID arbitrators. The jurisprudence on investment, treaty enforcement, and treatment in domestic African courts is very limited because nobody comes to enforce because it's Africa. And like I mentioned before, African parties generally tend to be on the losing end of ICSID awards. But having said that, I say it again, I love ICSID. I'd never give it up for anything. It's been a great contribution to world trade and world investment, and long may it continue, but in a reformed way. Thank you.
Thank you so much, Mr. Shashore.
Like I said, Roland and forget to call the nice bit, so I was just left with this my crumbs.
Well, I don't think so, sir, because going through history and also bringing the Eichmann case to perspective was I think it was very enlightening for every one of us. I want to say a very big thank you to Mr. Zaid, Mrs. Adekoya, and Mr. Shashari. We've had a quality 2 hours with you, just learning from you and, having a better perspective about in this investment disputes. It's been a good time.